I call the Honourable Member Carmel Sepuloni.
Thank you, Mr Speaker. Can I just congratulate you on your new role, Mr Speaker? I did last night when you were in the chairperson's chair, and I was told by the Minister, Simon Power, that I was premature in doing so because apparently you hadn't been accepted in that role. So I'm assuming now that you have been. I hope you have been. You're looking very comfortable. It suits you well, Mr Speaker. Mr Speaker, I'm standing to discuss Labour's views on the Legal Services Bill, and would like to say from the start that Labour does support this bill, but we do so reluctantly. And I think that my colleague Charles Cheval really articulated Labour's views well in his speech prior to Chester Borrows speaking. I will go over it again with regards to Labour's thoughts on the Legal Services Bill. We understand that the bill does overhaul the legal services system, and it is the legislative result of Margaret Baisley's review of legal aid completed last year, which found some failings in the delivery of publicly funded legal services. This bill will replace the Legal Services Act 2000. Labour believes reforms are necessary, with an emphasis on the public defender system, community law centres and a focus on quality assurance. However, we do have concerns about this bill and the government's overall direction with regards to its justice policy, which seem to be inhibiting access to justice. And I'll talk more about that shortly. Just to provide a bit of background, the purpose to this bill has been from the outset to promote access to justice by establishing a system that A, provides legal services to people of insufficient means, and B, delivers those services in the most effective and efficient manner. What we are concerned about, let's start with the Three Strikes Bill actually. We're concerned that Three Strikes will place further pressure on publicly funded legal services and will negate some of the good work that has been done in the sector. The number of defendants charged with serious crimes relying on legal aid will increase, given they will be more likely to plead not guilty to avoid being locked up for a long time. And these were some of the reservations and concerns that we expressed when the Three Strikes Bill was going through the House. And our reservations must be more widely shared than what National wishes to admit, because really that piece of legislation should have gone through the Justice Committee, should have been headed by the Minister of Justice, Simon Power, but we're pretty sure that he shared the reservations we had with that bill. Hence why, rather than going through the Justice Committee like it should have, I think it was the police. Was it police and law and order, the law and order select committee that looked after it? And I remember at the time, because I was actually on the select committee, and our concern was that really police should not have responsibility for a sentencing bill. However, the Minister of Justice washed his hands of it, and the Law and Order Select Committee was stuck with that one, and that's where it went. We disagreed with it. There are fundamental reasons why we were concerned, and we discussed them at that time. And now again our concerns about that arise with regards to this legislation. So the concern really was that the number of defendants charged with serious crimes relying on legal aid will increase, given they will be more likely to plead not guilty to avoid being locked up for a long time. And this will inevitably prolong the length of trials and place extra cost pressure on the justice system. So that really was our concern around the Three Strikes legislation. Dame Margaret Baisley's report uncovered some serious problems with how New Zealand's legal aid system operates. As a result, this bill is necessary to really restore taxpayer confidence in legal aid, which is, we'd all agree, is an indispensable part of our justice system. But this bill, unfortunately, will not achieve that, as there is no statutory consultative requirement in the bill with community law centres and the rest of the legal community. We are pleased, I have to say, that the Public Defence Service will be expanded, a system launched by former Justice Minister Phil Goff in 2004. The Public Defence Service is a good way to meet the rising costs of fees charged by barristers and solicitors in private practice. It creates a system of salaried public defenders and will standardise a high quality of defence. It really is a good alternative to legal aid. We are pleased the government is placing greater emphasis on community law centres. There was a time, I think, at the beginning of last year that we were actually concerned that their future might be at risk under this national government. So we are we are pleased that the government is placing a greater emphasis on community law centres, and that the Secretary for Justice will have the flexibility to utilise different means of delivering legal services. But we are disappointed that the obligations are not legislated for in this bill. And Taukinoria says there's no passion in this speech, but I tell you, we don't all need to be jumping up and down and yelling to demonstrate the fact that we take something seriously, unlike some people. Recently, last month, Simon Power announced that there would be a $402 million funding gap to legal aid in the next 5 years, and that further reforms are required. It is very, worrying, Mr. Henare. We hope that there will not be additional funding cuts, as the legal aid system is vital for large sections of the public's access to justice. Leanne Dalziel, one of our Labour colleagues, has previously expressed concern that many allegations in Dame Margaret's report was unsubstantiated, and called on Simon Power to meet with members of the Manukau Bar who claimed their reputations had been unfairly hurt by the report. The New Zealand Law Society expressed its concern that the report was based on anecdotal evidence and said the majority of legal aid lawyers were not corrupt and incompetent, yet there was a risk they would be tainted by the allegations made against the minority of practitioners. And I think this was a very valid and fair point made by the New Zealand Law Society. The Manukau Bar expressed similar concerns, and the government hasn't addressed this. So as I said, it was, we do feel that it was a valid concern expressed by the New Zealand Law Society, backed up by similar concerns from the Manukau Bar, and we do think it is something that the government should address, that the government should take seriously. We have some concerns about legal aid and employment disputes. The current system disadvantages union members because they pay $300 to $500 per year for their membership, which includes an insurance fee to cover the cost of representation for personal grievance claims. However, non-union members only have to contribute $50, placing them really at an advantage. And we would hate, we would really hate on this side of the House to see our union members disadvantaged anyway with regards to this. Thank you very much. I do recognise 2 minutes there, Mr. Speaker, but it's great having you signal that to me. So really, I really want to say again that Labour does support this bill, but we do so reluctantly, and I think that I've outlined the reasons why. In summary, it is things like the Three Strikes Bill and the repercussions of that legislation, that poorly thought out legislation. It is things like some of the allegations that were made in the Baisley report, allegations that had some serious concern expressed about them by the New Zealand Law Society and the Manukau Bar. There are other concerns. I'm sure that my colleagues who will speak after me will speak to those concerns, but as I said, Labour will be supporting this bill. Thank you very much, Mr. Speaker.
Mr. Speaker, I call the